This is the Daily Brief, one landmark court decision explained in plain English every day. Presented by FindCourtCases.com, this is your daily briefing on the law that shapes American life.
Okay, I want you to imagine something for a second. Picture this.
Right.
You're the publisher of a huge national newspaper, say the New York Times, and you run a full-page ad. It's paid for by civil rights activists, and it's pretty critical of the police in a city down south.
And this is 1960, remember. So the ad itself, the cost to run it was about, what, $4,800?
Right. And for that $4,800 ad, because it contained a few factual errors, and we're talking about pretty minor details here.
This is where it just goes off the rails.
An Alabama court awards a judgment of $500,000.
$500,000, which back then was an astronomical sum of money. And it wasn't just against the Times.
No, that's the crucial part. It was against each of the 4 black clergymen who had put their names on the ad.
You're talking about a judgment designed not just to punish, but to utterly destroy, to bankrupt a major American company, and to silence individuals.
The ability to engage in what the Supreme Court would later call, robust debate about what your government is doing, it was being choked to death by these kinds of lawsuits.
The stakes were, truly existential for the First Amendment.
So let's get into it. Our deep dive today is one of the most important First Amendment cases ever, New York Times Company v. Sullivan from 1964. We're going to explore how this case built the shield that protects almost all political criticism today.
And you just take one thing away from our whole conversation, let it be this single sentence.
Okay.
The case established that a public official cannot win a defamation lawsuit for criticism of their job unless they can prove the speaker knew the statement was false or acted with reckless disregard for the truth.
And that right there, that's the actual malice standard. It's this incredibly high bar that anyone from a police chief to the president has to clear if they want to sue a critic.
To really get why this was such a constitutional earthquake, we have to go back to where it all started. Montgomery, Alabama, 1960.
Right in the thick of the civil rights movement. And the plaintiff, the man who sued, was L.B. Sullivan.
He was one of Montgomery's 3 elected city commissioners. And his job specifically was to supervise the police department.
So the conflict starts when the Times publishes this full-page ad. The headline was, "Heed Their Rising Voices."
And it was, it was an appeal for money. It was to support student-led civil rights demonstrations happening all over the South.
The ad describes some pretty harsh police responses to protests in Montgomery. It claimed, for example, that police had locked students out of their dining hall to, quote, starve them into submission.
It also made some specific claims about the police treatment of Dr. Martin Luther King Jr.
And here's the problem. Some of those details were just wrong.
Yeah, they were factually inaccurate. The police hadn't actually ringed the campus, like the ad said. And some of the details about Dr. King weren't quite right. And these, relatively minor errors, they became the hook for this gigantic lawsuit.
Sullivan seized on them. But here's a question for you. His name wasn't even in the ad. So how could he sue?
That's the key to how these laws were being used. Under Alabama law, he argued the criticism was of and concerning him.
Meaning?
Meaning, since he was the commissioner in charge of the police, any criticism of the police was automatically a criticism of him. And the local jury, they completely bought it.
So the case goes through the Alabama courts, and the outcome is just brutal for the Times and the clergymen. The court said the statements were libelous per se.
Okay, let's translate that. That's a legal term, but it's so important to what the Supreme Court was about to reject.
Right.
Libelous per se basically meant that a statement was so obviously harmful to someone's reputation that the court just presumed the damage was done.
So Sullivan didn't have to show any proof that he'd been harmed, that he'd lost money, or that people thought less of him.
He didn't have to prove a thing. The court just assumed it. And they also assumed something else, that the Times had acted with malice.
The burden of proof was completely flipped.
Completely. It was basically a weapon for public officials to crush their critics. So the question that finally gets to the Supreme Court is, does the First Amendment allow this?
And Justice Brennan, writing for a unanimous court, delivers this thunderous no. They completely reverse the Alabama court and create this new constitutional rule.
Actual malice.
Let's really pin this down because, as you said, the phrase is so misleading. When we say malice in daily life, we mean spite or ill will.
Exactly. But in this legal context, it means one of 2 very specific things. Either you publish something knowing it was false.
So you're just lying.
You're lying. or you acted with reckless disregard for whether it was true or not.
Okay, but hold on a second. Let's push on that. The Times admitted they didn't check the facts in the ad. In fact, they had articles in their own newspaper files that contradicted what the ad said. Isn't failing to check your own files? Isn't that pretty reckless?
It's a great question, and it's the exact tension the court had to work through. They looked at what the Times did, or rather, didn't do.
Relying on the sponsor, not checking their own stories.
And they concluded that, at worst, this was negligent. It was maybe sloppy journalism. Careless, even.
But negligence isn't malice.
Exactly. That is the entire ballgame. Negligence is a mistake. It's a failure of care. Reckless disregard, the actual malice standard, requires something more. It requires the plaintiff to prove the publisher had like a serious doubts about the truth of the statement, but published it anyway.
It's a much, much higher state of mind to prove.
It is. And the court set the bar that high on purpose for what they call breathing space.
Breathing space.
The idea is that if every single factual mistake, every bit of carelessness could lead to a ruinous lawsuit, nobody would risk criticizing the government. Speech would be chilled.
People would just shut up to be safe.
Right. And the court said that in a democracy, the pursuit of truth has to be willing to protect some falsehood along the way.
What about the fact that this was a paid ad? Doesn't commercial speech usually get less protection?
Another fantastic point. And the court dealt with it head on. They said that when a paid ad is communicating ideas and opinions on, a matter of huge public importance,
like civil rights,
it gets the full protection of the First Amendment. The fact that money changed hands didn't matter because the speech itself was fundamentally political.
So let's tie it all together. The Times and the clergyman won because there was just no evidence they knew the ad was false or that they were reckless.
None. The evidence just wasn't there to meet this new, very high constitutional standard.
And the court didn't just define the standard, it also shifted the burden of proof, right?
Fundamentally. Before, Alabama just presumed malice. Now, the Supreme Court said the burden is squarely on the public official on Sullivan to prove it with clear and convincing evidence.
Let's talk about the human impact of that. For the civil rights movement, this must have been like a shield being handed to them.
It was a lifeline. It meant activists and newspapers could challenge powerful officials, like a police commissioner in the segregated South, without the constant fear that one small factual error would lead to financial ruin.
It basically de-weaponized libel law as a tool of political oppression.
It did. It said that the value of criticizing your government, even if you do it imperfectly, is more important than protecting a public official's reputation from that criticism.
And the legacy is just enormous. This one ruling basically forced every state in the country to rewrite its libel laws when it comes to public officials.
It did. But we should be clear, this is still a really divisive decision. Even today, smart, reasonable people argue about whether the court got the balance right.
Okay, so let's unpack that debate. What's the argument against Sullivan?
Well, the argument is that the bar is now just too high. Almost impossibly high.
How?
Critics say it gives a free pass to powerful media organizations to be sloppy. That a local mayor or police chief can have their reputation destroyed by a false story. But unless they can somehow prove what was in the journalist's mind, that they knew it was false, they have no way to fight back.
They have no legal recourse to clear their name.
Essentially, yes. They argue it puts the thumb on the scale too heavily in favor of the press.
And the other side of that argument, the one that won in 1964.
It's that the actual malice standard is the only thing standing between us and that chilling effect we talked about. If you lower that bar back down to just negligence,
then every small newspaper, every blogger, every activist has to be terrified of making a single mistake.
Exactly. The risk of a lawsuit would be so great that a lot of important critical journalism just wouldn't happen. The system of holding power accountable would grind to a halt.
So when we look around today, its relevance is just, it's everywhere.
It's the foundation. Every piece of investigative journalism you read about a public figure, every editorial cartoon, every bit of sharp political commentary on TV, it all exists in the legal world that Sullivan created.
Anytime a politician threatens to sue a news organization for a critical story, this is the case, this is the shield that stands in their way.
It all comes back to Sullivan.
So to bring it back to that one core idea for you, the listener, Public officials have to meet an incredibly high standard actual malice to win a libel case. And that standard exists to make sure the debate over public issues remains, as the court said, uninhibited, robust, and wide open.
And it's so important to remember why the court protected those erroneous statements.
Yeah.
It wasn't because they liked falsehoods.
No.
It was because they believed that protecting some error is the necessary price we have to pay.
It's the cost of doing business in a free society. That's the breathing space. The real winner of this case wasn't just the New York Times, it was the free exchange of ideas itself.
And maybe here's the thought to leave you with. The next time you read a really tough investigative piece about a powerful government official, just think, how many tiny factual details in that long, complex story might be slightly off, just a little bit wrong? Now imagine if the legal standard for that story to exist was perfect accuracy. If the journalist could be sued into oblivion for simple negligence, for one mistake, what stories would never get told? What truths about Tower would never come to light? That's the world New York Times v. Sullivan prevented.
You've been listening to The Daily Brief, one landmark court decision explained in plain English every day. Presented by FindCourtCases.com, this is your daily briefing on the law that shapes American life. Thanks for listening. We'll be back tomorrow with the next case.